I have about 15 minutes to cover the entire field of evidence as applied to repressed memory cases, and I think I've got an insurmountable task, but I'll do my best. The concept of repressed memory and recovered memory is a new one to many courts and a changing one, and it raises unique evidentiary issues. The whole concept of repressed memory, as you know, is a very controversial one, and there are disputes among the experts, there are disputes among the parties, obviously, and there are disputes among the courts and among the judges themselves. An interesting thing to note in reading cases in this area is that there are many dissents, many more than in most areas of the law. There's also a very high emotional level to the debate concerning repressed memory or false memory, probably because the cases often involve sexual abuse or alleged violations of position of trust. And maybe it's because of this high emotional content to the debate that the decisions come out being so inconsistent and difficult to harmonize and sometimes irrational. How is repressed memory, how is the theory of repressed memory used in the courts? Well, first it's used as substantive proof that something happened, for example, of guilt or innocence in a criminal case or liability in a civil case. And second, it's used by a plaintiff in a civil case to defeat a defense of the statute of limitations. Those are the two principal ways in which this doctrine comes to play in court. Is recalled, previously repressed memory relevant and material for admissibility purposes? Because if it isn't admissible, or testimony about it is not admissible. Well, the answer is it depends. Relevant evidence means evidence having the tendency, any tendency, to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And the federal rules of evidence, and I'll cite to them primarily because they're pretty consistent with the state rules of evidence, provides that relevant evidence is admissible. So if the witness's recollection that's been refreshed relates to an issue in the case, for example, whether the witness himself has or has not been abused, and if it tends to prove that it's more likely than not that it did happen, then it's admissible. It's relevant, it meets the test. The real question in this area, though, doesn't have to do so much with relevancy and materiality as it does with competency. And the question really is the testimony competent, or more properly, is the witness competent? The key issue is whether the witness, usually the alleged victim, really possesses knowledge of anything. When the witness has recently recovered something that he or she states that they haven't known for months or for years, there is a real question as to whether that witness has knowledge of anything that's pertinent. The rules provide that a witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Now, that testimony, that base foundation testimony that has to come in first before the witness can testify, can be offered by the witness himself, who can say, I do have knowledge of this, and here's how I got it. Underlying all of these issues about competency and relevancy is the court's inherent power and express power under the federal rules to determine whether the probative value of the testimony being offered outweighs its potential to prejudice a party or to confuse or mislead the jury. And I think the evidence in the area that we're in is particularly capable of confusing, of prejudicing, and of misleading a jury. The rule states that although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice or misleading the jury. That is a rule that should be invoked far more often, I think, than it is by defendants in these cases, because in many, many cases, it seems to me, the recovered memory has a very high potential to mislead and not to prove much at all. What the court has to do before allowing the testimony in is determine how legitimate this testimony is. If the court determines that it's not sufficiently competent or legitimate, it doesn't come in. One problem here is that the case is being tried non-jury to the judge himself. The judge determines that this evidence, or as a preliminary matter, that this evidence is sufficiently sound that it's coming in. The judge has really decided the whole case in the process of deciding a preliminary issue. Can the court take judicial notice regarding concepts in this repressed memory area of the law. A court can take judicial notice regarding the validity of things of facts that are not subject to reasonable dispute if they're generally known or if they're capable of accurate and ready determination by resort to sources whose accuracy cannot be reasonably questioned. Can a court take judicial notice of some of the concepts here involving repressed memory? Probably could, but the courts have not done this. Judicial notice does not play a major role in these cases, probably because the cases tend to be too fact-specific, and also because there is no consistent view regarding the facts underlying repressed memory. The fact is that the repressed memory notions are very much subject to debate, and there is no agreement on them. The courts have held, by and large, that there is a need for expert testimony before repressed memory can be admitted as evidence in a case. Theoretically, a plaintiff could come in and testify at trial based upon a repressed memory and say that I didn't realize this for a while, but now I do. It suddenly came back in a flash, and I'm testifying to what I now remember. The way it goes down, or as it happens in court, because of the complexities of these notions, is that the courts do require expert testimony before refreshed memory testimony is allowed in. What are the standards for allowing into evidence opinions of expert witnesses regarding repressed memory? Well, first and foremost, the expert has to be qualified. The plaintiff obviously attempts to portray his or her expert as highly qualified in terms of education, training, experience, previous qualification as an expert in court. And it's the defense's job to object to the qualifications wherever an objection is appropriate. The defendant should object to the specialized training that the witness may not have received. And the defense obviously has to attempt to undercut the credibility of the expert witness offered by the plaintiff. The defendant may attempt to weaken the expert's testimony by showing bias or prejudice. For example, an inclination to testify only for plaintiffs and never for defendants. And it's very important for defense counsel to know the expert's track record in terms of testifying in these cases. And that track record can be determined through discovery, through depositions, and through independent investigation. The defendant can also challenge the sources of information being used by the expert and exploit any inaccuracies in the facts that are being used. It is really the job of defense counsel to know those facts better than the expert testifying for the plaintiff does. And a defendant can attempt to weaken or impeach the testimony of the plaintiff's expert by resort to prior testimony by that same expert, which might be inconsistent in some respect with what's being offered at the trial in question, or by going to published writings published by that same expert, to show inconsistencies between what he's written and what the testimony is. A defendant can obviously also attempt to show that proper techniques were not used to recall the memory and that a set of facts was suggested to the plaintiff, which seems to often be the case. And a defendant can attempt to challenge the underlying theory of repressed memory itself, because it's on the basis of that whole theory that the expert is testifying. That is the foundation for the plaintiff's expert's testimony. There is an open question as to whether these notions about repressed memory are legitimate scientific theory at all, and they have to be. If they're not, no expert should be testifying and rendering his or her opinion based on this alleged body of knowledge. The law in this area, until the federal rules were passed, was known as the law set down in the Fry case. It was called the Fry test, which is a 1923 case in the District of Columbia. And that case basically held that scientific evidence is admissible only if the principle on which it's based is sufficiently established to have general acceptance in the field to which it belongs. However, when the federal rules of evidence were passed, things were changed. And Federal Rule 702, which addresses expert testimony, sets out a different standard. If scientific, technical, or other specialized knowledge will assist the trier of fact, the jury usually, to understand the evidence or to determine a fact in issue, a witness qualified as an expert by knowledge, skill, experience, training, or education can testify thereto in the form of an opinion or otherwise. The Supreme Court recently in the Dober versus Merrill Dow case, which was discussed previously today, I believe, in 1993 held that the Federal Rule of Evidence 702 prevails over the old Fry test. However, the subject to which the expert is testifying must be technical or scientific or specialized, and the expert's testimony must be supported by good grounds, and that's a quote. The court is supposed to focus on the principles being used and on the methodology and not on the results. The court might disagree entirely with the conclusions reached by the expert, but if the principles and the methodology seem sound, then the court can allow that evidence in, and there is the rules do favor the admissibility of evidence as opposed to the exclusion of evidence. The court has to make a preliminary assessment about the methodology and find that it's valid before allowing the testimony to come in. The factors that the court's supposed to look at before determining whether to allow in this expert or these experts offered by a plaintiff in one of these cases, for example, include the following: whether the scientific knowledge can be tested somehow. And in this area of repressed memory, the results often cannot be tested, and that is one of the primary tests to be looked at by the court. Another factor is whether the scientific theory has been subjected to peer review and has been published. Certainly, a lot's been published in this area. Another factor is what is the potential rate of error regarding the scientific theory involved. How high is the high potential rate of error regarding repressed memory opinion would suggest that experts would often be excluded. You might ask, how do claimants get this repressed memory expert testimony before the jury, given these factors which the court is supposed to consider? Well, it happens every day. And it is somewhat surprising that some of the experts who are allowed to testify are indeed allowed to testify. The trial court has the discretion, again, to exclude all evidence, including expert testimony, if the probative value is outweighed by the prejudice or the capacity to confuse. Let me touch briefly on a couple of related issues involving hypnotism, which sometimes is involved in these cases. Where the plaintiff's memories were retrieved by hypnosis, the defendant's expert should be prepared to testify that the techniques that were used by the hypnotist were fraught with weaknesses and problems, and therefore the hypnotically refreshed testimony should be excluded. Now, empirical evidence can be cited for both sides in this hypnosis debate regarding the reliability of testimony that has been brought about through hypnosis. This is another very hotly contested area. The issue of hypnosis in litigation was first addressed, as far as I can tell, in a California case in 1897, where hypnosis was used to induce a witness's recollection, and the court there in California, about 100 years ago, said, the law of the United States does not recognize hypnotism, period. And that was simple and straightforward. But things have changed. And now there are basically three views respecting the use of hypnosis. First, that hypnotically obtained evidence is not admissible at all. And secondly, that it is admissible, and the fact that hypnosis was involved simply goes to the weight of the evidence. And third, that the matter gets decided on a case-by-case basis by the court using the following considerations: the question of the hypnotist, the appropriateness of using hypnosis to revive this particular kind of memory given the particular condition of the subject, whether there was any suggestion of facts or information to the subject, whether the hypnotist complied with reasonable procedures regarding reliability, whether there was some corroboration of the substance of the testimony, whether the witness had a motive to fabricate, whether the witness was amenable to cross-examination, to meaningful cross-examination. And the point there is that after someone has been hypnotized, they may be so convinced of something that they are not really subject to cross-examination at all. There's a lot of conflict in this area of evidence. In Illinois alone, some courts have held that in a criminal case, the prosecution can offer hypnotically refreshed testimony, while another court has said that the prosecution can never offer hypnotically refreshed testimony in a criminal case. This is in the same state. An interesting case involving this sub-area of refreshed recollection is the Berwick versus Shay case. In that case, Ms. Berwick in 1992 sued her aunt and uncle for sexual molestation that had allegedly occurred 30 years earlier. The defendants asked the court to exclude from evidence the testimony about the plaintiff's hypnotically refreshed recollections. The plaintiff had been referred as a result of some physical problems to a hypnotist named Val St. Regis. Now, before seeing this St. Regis fellow, Ms. Berwick had only remembered some sexual abuse by her parent. After the hypnosis, she, lo and behold, recalled sexual abuse by aunt and uncle. The court, in this case, concluded that hypnosis was appropriate for the kind of memory loss involved, but the court took into account the fact that devastating damage can be done by charges of sexual abuse. And really putting a lot of weight on that, the court held that there has to be corroboration of hypnotically induced testimony in order for it to come in. The problem for the plaintiff in the Berwick case was that there was no corroboration. On top of that, the hypnotist did not appear to be the world's most qualified hypnotist. Starting at age 15, he'd followed a psychiatrist around Europe and India and other places in search of faith healers. He'd appeared as a stage hypnotist in nightclubs and at resorts. He wasn't licensed anywhere, and he'd never testified as an expert, yet the plaintiff's case was really completely founded on this testimony which was elicited by this hypnotist. A very significant point was that the hypnotist had not tape recorded or videotaped his initial interview, which is essential if testimony that's been refreshed by hypnosis is going to be admissible. He said he'd have notes, but the notes had disappeared. This may have led the court to come down the way it did, but the court established some good basic rules in this case, including the fact that there had to be corroboration and that there was a higher standard for evidence which was produced as a result of hypnosis than there would be for other testimony. And the court held that the burden of establishing admissibility of this kind of evidence was by a clear and convincing evidence standard. And Ms. Berwick simply didn't meet that test. It's obviously essential for a plaintiff who wants to use hypnotically refreshed testimony to have the hypnotist dot every I and cross every T, and also to be prepared to meet a clear and convincing test. The Supreme Court of the United States touched on hypnosis in a criminal case where the defendant wanted to testify that after being hypnotized, she realized that she had not shot her husband and did not have her finger on the trigger of the gun when the gun went off. The killing occurred while the husband was physically assaulting the defendant. The Arkansas trial court had refused to allow her to testify because of its per se rule that we don't allow hypnotically refreshed testimony in our courts. Bear in mind, this was a criminal defendant who has a right to say her piece and make her defense. The Supreme Court of the United States struck down Arkansas's per se rule in favor of the defendant's right to testify on her own behalf. The court concluded that it was, and I quote, not shown that hypnotically enhanced testimony is always so untrustworthy and so immune to the traditional means of evaluating credibility that it should disable a defendant from testifying in a criminal case. And the court noted that in other states where they had an exclusion rule excluding hypnotically refreshed testimony, it was for the testimony of witnesses, not for the testimony of a criminal defendant. The Supreme Court noted that there were three general characteristics of hypnosis that could lead to inaccurate memories. First, that the subject is extremely suggestible and tries to please the hypnotist with good answers. Second, that the subject is likely to confabulate or make up details to fill in gaps. And third, that the subject experiences memory hardening, gaining greater confidence both in what's true and what's false, and making the person virtually impervious to cross-examination. The court said that to lessen the potential for these inaccuracies, procedural safeguards would help, including taping all of the interrogations, both before and after hypnosis, corroborating evidence, expert testimony, cautionary jury instructions, and full cross-examination. Is there a duty on the part of a party who is using a witness whose testimony, whose recollection has been refreshed through hypnosis, to tell the other side and to tell the court that the witness has been hypnotized? I don't know that this is clear. In civil cases, surely if you're asked that question in discovery, you'd have to answer, but if you aren't asked, I suppose you don't have to say. In criminal cases, there are some courts that hold that there is such an obligation. that the party who has hypnotized the witness and is going to use the witness's testimony must advise the court and the other side that this has occurred so that the court can rule on whether the testimony is admissible. Obviously, in any case where hypnosis might have been used, the defense, either in a criminal or a civil case, should make a specific request for disclosure concerning hypnosis, who did it, how did it happen, and so on. And if this happens in the middle of a trial, the party against who it's being used should seek a continuance to depose the hypnotist in a civil case and to obtain a rebuttal expert. Courts have held that parties are generally entitled to cautionary instructions if hypnosis has been used in a case, instructing the jury not to place undue weight on the testimony, and additionally that hypnosis cannot assure that the testimony that was offered was truthful. An excellent case in this area, an excellent opinion, is the State versus Heard case in New Jersey, and that court, in addition to a wonderful analysis, said that a pretrial hearing is required to examine the procedures used in the witness's hypnosis before that kind of testimony can be used in any case. Let me touch real briefly on truth serum. Truth serum generally, some people think it can be used to induce an alleged recollection of facts, but to date, to my knowledge, the majority view is that these drugs have absolutely no legitimate use in recovered memory cases. How about lie detectors? One might ask, why not simply, in a case involving alleged sexual abuse from years ago, why not simply have the person claiming to have been abused based on a recollection of a memory previously repressed, hooked up to a polygraph examination? Let's see, and hook up the accused as well, and let's see who's telling the truth. Well, the theory of polygraphs, as most of you probably know, is that it measures internal stress, and that internal stress accompanies lying, and that's probably true as far as it goes. But there's a tremendous potential here for error. About 4,000 years ago, this process of polygraphs was begun when the Chinese would use it when they would try a criminal defendant. They would have a physician present who would listen or feel for pulse, change in heartbeat, and so on, and announce whether the person that was testifying, the accused, was telling the truth or not. And modern lie detector tests work basically on the same kind of theory. They measure blood pressure, pulse, respiration rate, and perspiration, and so on, and compare the responses to the key questions to responses to control questions. The reliability of polygraphs is fiercely debated, and not surprisingly, the polygraph examiner crowd tends to say that they're extremely accurate, almost 100%, but that is not a consistent view. Many psychologists and other experts believe that the accuracy rate is much, much lower, and also that what really is being measured is anxiety, and anxiety is not necessarily the same thing as lying. You may be anxious and not be lying. And on top of this, some people are able to mislead the analyst. The courts have taken three positions in this area. First, that polygraph tests are inadmissible, period. A minority view says that the trial court may admit the results if the parties stipulate before the test is taken that however they turn out, the results are going to go in. And a few jurisdictions say it's simply up to the trial judge. The trial judge can allow that evidence in or not. Courts have expressed concern that jurors would be unduly impressed with this kind of testimony, this scientific evidence. And while you might get a cautionary instruction saying don't pay too much attention to the polygraph evidence, that might just highlight it even more. There's also a concern that if this evidence became admissible generally, criminal defendants would be under pressure to sacrifice their right against self-incrimination. If they didn't take the test and a jury was waiting to hear about the polygraph examination, they're going to be convicted because they didn't take a polygraph. And if they do take it and answer questions, they may be convicted because they flunked. And there is a Fifth Amendment constitutional privilege not to have to testify against yourself. The biggest problem in this area is that the polygraph examination simply is not as accurate as it has to be given the consequences that rise or fall in this area. Let me touch on profiles and character evidence. There are increasing efforts to use scientifically created profiles in abuse cases. For example, prosecutors have attempted to use sexual abuse accommodation syndrome profiles for children to prove that the sex abuse happened and to explain a delay by the child in reporting it, and also to prove that children who report this thing are generally truthful. When a plaintiff in a civil case or the prosecution in a criminal case tries to use a profile as part of its case involving repressed memory, the defendant should object on the ground that the rules of evidence prohibit evidence of character, which is what this really is, a profile, that someone meets a profile is really evidence that they have a particular character trait that would make it more likely that they had done the thing in question. The defendant should move to prohibit the evidence of character, move to prohibit this evidence on the grounds that it is really evidence of character and that it does not show what happened on the occasion in question. The federal rules provide that evidence of a person's character is not admissible for purposes of proving action in conformity therewith on a particular occasion. In other words, you can't prove that because someone has a particular type of personality or character, they very likely committed the event charged. Now, evidence of a pertinent character trait or a trait of character may be offered by an accused in a criminal case or by the prosecution to rebut that, but that's a separate area. A defendant in a criminal case rebut that with opinion or reputation testimony concerning that person's character from other sources. Some people have suggested allowing that rule to exist as well in the civil domain and allow civil defendants, for example in an abuse case, to put their character in evidence to prove that they are law-abiding people who would not have done the thing that was charged. The concern is that this would distract jurors from the event that is really to be decided and would also have the effect of rewarding good people and punishing people with a good reputation and punishing people with bad reputations, despite what the evidence might show had occurred with respect to the event in question. Now, the same rule includes the other crimes rule, as it's known, which in essence says that a plaintiff cannot prove that the defendant did the act charged by showing he may have committed other wrongs before or after the alleged event. Such evidence is admissible for some specific limited purposes, but generally you cannot prove that someone did this because they had done other things. And in the kind of cases that we're dealing with here, a plaintiff should not be allowed to prove his allegations of abuse by trying to prove other alleged bad acts of the defendant. All witnesses, including a plaintiff or a defendant, can have their credibility attacked or supported by evidence in the form of opinion or reputation if that opinion relates to character for truthfulness. Of course, in any case, a witness can be impeached by a prior conviction, but that usually is not involved in these cases. Let me touch on a couple other points, and then I think we'll have a brief period of time for discussion if we're lucky. No? All right, I'll be out of here. Oh, we're being evicted. All right, just let me close up. Regarding some procedural considerations, it is essential that defendants object to the use of repressed memory in a timely fashion, that is before the trial has begun. This should be done by filing a motion in limine, the basis of which is basically that the witness simply is not competent and does not have knowledge, and therefore the testimony should be excluded. I think I'd better close up. Well, I have a good deal more, but I don't know if there's any real point to trying to rush through it. It's been a pleasure. Thank you very much.